Good morning. Please be seated. We're here in our case 1 CV160440 FC BACHRACH versus BACHRACH. Each side will have 20 minutes to present their argument. You may reserve any time that you want for rebuttal, but you have to keep track of your own time. We have a clock at the podium to help you do that. We're recording the argument. It should be on YouTube in 2 or 3 days. Because we're recording it, please identify your client and yourself so that we can keep track of things. We've read the briefs, we've looked at the record, and we've conferenced the case, so we're familiar with the case. So when you get up to argue, just launch right in and tell us what you would like for us to know. Counsel, you may begin.
Morning. Keith Berkshire for Appellant Randy BACHRACH. May it please the Court. It isn't often that I get to stand up here and say on an issue that there's a case so directly on point as there is with the Garrett case in this matter. It literally is identical facts to the situation at hand regarding the contingency fees in the cases that my client was involved in, where it was before and after the date of service. Garrett is directly on point. It discusses how to allocate proportionally the contingency fees in relation to the number of hours worked prior to and after the date of service.
Except Garrett dealt with the statute in a prior iteration.
Maybe so. However, the statute still has the date of termination under 25-211 and 213 as the date of the termination of the community as the date of service. So in the court in this case on page 2 in their, I think, second finding found that the community terminated on September 8th, 2014. So in that case, if we don't hold that the date of termination of the community is the date of service, what date would it be? I mean, the statute, both statutes, 211 and 213, couldn't be clearer. The court in this case used the Morey case and the Goldstein case as its basis to find that these contingency fees were essentially accounts receivable. Morey has maybe 4 sentences on this issue, and it refers to the Goldstein case as its basis for this theory of law. Goldstein, if we read Goldstein, it was uncontested in Goldstein that the accounts receivable in that case were from community efforts prior to service. The court actually found this on page 24. The appellant doesn't dispute the fact the accounts receivable represents an asset which arose from his efforts during marriage. So this wasn't a contested issue in either case whether the accounts receivable were related to something after the termination of the community or after the date of service. They were from prior, which we don't contest. My client never contested that the effort made prior to the date of service was to be proportioned to the community, and what was made after the date of service was to be proportioned to him. So in essence, we do agree with the holding of Morey and Goldstein from that standpoint. In the response brief, Appley tries to argue that the ruling on the motion to reconsider, or motion for reconsideration in Garrett, is what should be looked at. And that specifically dealt only with complex cases with multi-party litigation. That didn't exist here. And honestly, if that was the situation that did exist here, our position is that the court just retains jurisdiction on these issues and deals with them at the time that the cases are finally resolved. So they could make that argument at that time if that's the situation. But there was no even allegation that there were multi-party litigation or that 80% of the case had been dealt with, as the example that was put forth in the ruling on the motion to reconsider in Garrett if it was multi-party litigation. So those issues could still be brought up at the time that the fees were to be distributed at the end of the case. However, the problem is that the court ruled in this case and picked this artificial date as of the date of the decree, which in our situation was 21 months after the date of service. We point out in our reply and in the opening brief that one of the repercussions of doing this was that while my client was paying support to wife during the case, paying all the living expenses, he also then had to give her 50% of his income during the entirety of the case. So in essence, she got the majority of the income because she got half of all of the income earned under the court's ruling, half of all the income earned up until the date of service, or up until the date of the decree, plus he was paying support. So in essence, she ended up with more income than he did during the pendency of the case. The interesting part about the case below is that the trial court did get one of the cases, one of the contingency fee cases right. In the Esguerra case, the court utilized the proper methodology from Garrett. My client testified about what percentages of the hours were done prior to and after the date of service, the exact dollar amounts on all of these items, and the court utilized the correct method on that case. So in essence, the court utilized two different valuation methods, if you want to call them that, dealing with different cases under the exact same set of facts. The only difference with the Esguerra case is the Esguerra case was completely done prior to the date of the decree. But despite that, I mean, under the court's theory on the other cases, the Presidio and the ERISA cases, then the court should have given 100% of the fees to the community under the same theory. So, but the court didn't. It utilized different valuation methods based on which case it looked at that time. So our position is that the Presidio and the ERISA cases need to be remanded for an order that the court retains jurisdiction until these cases are done, and at that time the court should allocate any contingency fees, if there are any, because again, Presidio is an appeal, and if they're unsuccessful, they get nothing. That they should allocate the percentage of fees based on the amount of hours done prior to and after the date of service in accordance with Garrett. The most concerning case, I think, was the small water damage case, or I think it's referred to as the condo case in the trial court's ruling. In that situation, the trial court specifically found that this case retained after the date of service. Now, Appellee argues that there was no fee agreement or something else to that effect, and so we couldn't prove when it was done or anything like that. We don't need that. The trial court found in its decree that the case retained after the date of service. And if that's the finding and the community terminated, that case has to be solely owned by my client because it only was worked on after the date of service. Appellee also argues that this argument was waived because of the instruction in the or comment, I guess, in the decree of dissolution regarding right after the findings on the law practice that if either party thought that the court got it wrong, they could file a motion for new trial or reconsideration. There's no case law out there that makes motions for new trial mandatory in this type of situation. I mean, it's a rule. We could have obviously filed it if we wanted to, but there's nothing that makes that a waiver claim if you don't do so. Moving on to the art. Now, this is an interesting issue because it comes up, personal property comes up in most divorce cases. And in very few divorce cases does anybody have appraisals about what their personal property is worth. And so what the trials courts do in most situations is they try to divide it as fairly as they can, either based upon the testimony of the parties, or honestly what is a very common way that the trial court divides this is, husband, you make 2 lists of property, wife, you pick which list you want. Or eeny, meeny, miny, mo. That ends up in a lot of trial court rulings because most people can't afford to pay for an appraisals of personal property couches, TVs, and those types of things. So this is such an enormously common issue for the trial court to have to resolve. And what this court did could be essentially done to any family law case regarding any personal property. You didn't prove it could sell, therefore, one of you gets all of it. The court could easily say, neither of you proved what the furniture was worth. Wife, you get all of it because you picked it out. Or husband, it was on your credit card, so you get to keep it. I'm just going to call it worth zero. Both parties testified they thought the art had value. Wife stated $1,500 apiece, which husband offered to buy it at. He offered $54,000 or $27,000 to wife for her half of all the art.
And do they have the funds to pay that?
He testified that he would come up with them. There was a settlement that husband got regarding a wrongful death case regarding his son that was discussed in the pleading. So he did testify that he would come up with the money to buy it. So again, in the trial court, this happens all the time when the parties are contesting the value of a house or the value of a car. The court essentially typically utilizes which party's willing to pay more. You think the house is worth $1 million, you think it's worth 1.5, well, you can buy it at 1.5 because there's a greater benefit to the community in that regard. Not you found it on Zillow, therefore you get to buy it for $1 million or zero. And that's what the trial court did here. The easiest and most equitable solution in this situation, if the court can't come up with a value and both parties want it, is split it in half. This isn't one item. There's 23 to 36 items here that the court could easily have said, each pick one until the list is gone. But no, they attributed the value at zero. And interestingly, the way the court wrote this is the exact same way that wife wrote it in her pretrial statement, that the art should all be returned to her. I think there was even a comment in the transcript where it was, quote, part of her as being part of her artistic expression. Well, the same argument could apply, to husband's law practice, that's part of him, but we're not going to value it at zero. So husband offered to buy it. This isn't something which typically happens in the trial court where somebody says, I want you to have all the household furniture, but you should be attributed $100,000 for it, so give me my $50,000. This is someone offering to buy it. And if we extend what this court did in the Cohen v. Frey case about getting the maximum benefit even to wife, if she thinks it's worth nothing, is to give her $27,000 for it. It's hard to say that $27,000 is not more than zero. If you think it's worth zero, you'd happily sell it for $27,000. So, and that's all husband asked in this case, that either pick a value, and he even stated at wife's value, the $1,500 per item, which resulted in the $54,000 amount. But to say it's zero, this is an end run around Toth of just saying, well, I'm just going to say it's zero to get around the fact that this is clearly an unequal distribution of the assets. In the answering brief, wife makes the argument that, well, the court could have considered this when it talked about the woodworking equipment and the jewelry and so forth. But if you read the decree, the court clearly allocated the jewelry versus the woodworking equipment and went through that neither party could prove what was separate, what was gifts beyond two pieces of jewelry that wife proved were gifts. And it stated these two items are offset against each other specifically. They kept them in the same paragraph and so forth. The art was just dealt with as it's worth zero because nothing is ever sold. Well,
counsel, yeah, I'm assuming that neither party took advantage of the opportunity to have these items appraised, these paintings appraised. I mean, there are art appraisers, right?
Correct.
And isn't the court entitled to take that into account, that the parties here chose not to do that?
I think the court can. There's case law that you can always testify about the value of your own property. And this isn't an issue that wife said they're worth nothing. Wife admitted that they're worth at least $1,500 apiece. It's her testimony. This isn't something that husband is trying to just make up. She's saying, hey, it's crayon drawings that my kids did, they're worth zero. She admits they're worth something. So we have a range here from where wife's claim to husband's claim of value. The court went outside those positions and just said it's worth nothing to give it to wife. So she admits there's a value.
So you think, as a trier of fact, the court automatically abuses its discretion when it chooses to disregard those parameters?
I think that it has to be very careful to go below what both parties admit a value is. If the court had both parties testify the house is between $500,000 and $550,000, can they pick $200,000? I mean, I think they're limited by the facts of what the parties pled or testified to. If the lowest position the court has is $1,500 apiece, I think the court, it's tough for the...
Is that really true, though? Apparently, the artwork was attempted to be sold. No one bought it. So at least in the wider art market, at least there's evidence that the value is zero because no one bought them. Can't the court take that into consideration when in figuring out what it's worth?
I think the court can obviously take into account what the market value is.
But,
But by the same token, the market value of most people's furniture in their house is probably zero. Who buys old mattresses? Who buys old sheets and clothing? Most of people's stuff that we divide into divorces probably would have zero market value, but it still needs to be attributed to somebody.
Well,
again, if we look at our case law on businesses, we don't use necessarily always market value. We use a going concern, a value to the party, and that's how we value businesses. So I think the same argument could be made here.
Well, counsel, if there is a replacement value for furniture and things that are in people's houses, it's hard to, so that kind of stuff can be valued in a way. Artwork is different. And I guess my earlier question to you is, what is wrong with the trial court considering the one point it says it's worth $1,500, the artwork was attempted to be sold, it wasn't sold. I thought, considering all the evidence, I value it at zero. What's wrong with that?
Well, even if they valued it zero, if you want a substantially equal division, which is what the court's goal is under Hatch and Sample in all these cases, if you don't know the value or value at zero, split it in half. That's the more equitable solution than just giving it to somebody. Again, just stating that something's valued at zero ends up being a very easy way to get around the presumed equal distribution that is required, especially since, again, this is the oddity of this case, is that husband offered to buy it. He wasn't trying to push it on wife at $50,000, which is what typically happens in these cases. He offered to buy it. So if the court follows Cohen and says, we're supposed to get the maximum benefit for the parties, then the idea would have been to sell it to husband, or at least split it in half. I mean,
so, as a public court, we have to be mindful of the standard of review. Are we reviewing the trial court's decision here as an abuse of discretion, or did the court make some error of law here?
We're arguing that they used an improper valuation method, which would put it as an error of law, because they didn't actually look at a potential sale. Even though it was to husband, they didn't look at that. We're arguing that the valuation method itself. I wanted to move on to the spousal real quick, which was, our position on this is that he simply didn't have notice. Frankly, wife didn't have notice that she was going to get 10 years because she never asked for it. Now, there are no cases directly on point on whether this can be extended. The most we found was the Smith v. Tang case that talked about judgments in excess of what somebody asked for. In that case, the Supreme Court remanded it and said, if the court, it was clear the jury wanted to give you the maximum, you get the maximum, that's it, that you requested. In this case, the maximum would have been 5 years. And these cases are litigated as the amount and the term. You ask different questions on this. If husband didn't know that it was a potential for 10 years, because wife stated during her testimony and in her pretrial 5 years, you ask different questions, you present different evidence based on the length of the request. How, based on how much education or other things it's going to take to be rehabilitated. Husband had no notice that there was going to be a potential for 10 years here. And again, the amount exceeded the total amount. If we add up her claim for 5 years and what the court gave for 10, as a total amount, the 10-year award ended up at a higher number overall as a lump sum. So our argument is that the husband didn't have notice, that this would be a violation of Volk or Cullen on cases about notice on those type of issues. And I'd like to reserve the last minute and a half for rebuttal.
Thank you, counsel. Counselor?
Good morning. May it please the Court, my name is Scott Patterson, and I represent Natasha BACHRACH, the appellee in the case. In the pretrial, the parties identified the issue on the cases as apportioning wife interest in husband's law practice. Specifically, wife requested her interest in all remaining cases and accounts receivable. Wife noted in the pretrial she did not believe that husband's itemization of the hours he worked on each case was accurate, and her belief that husband may have turned over cases to co-counsel in order to reduce the community interest in those cases. Wife noted that husband had not disclosed any copies of fee agreements, representation agreements, or other engagement letters to document how his fees were to be paid in any of the 5 cases. In the pretrial, husband presented that he had 5 cases that were active in his practice and relevant to the divorce. He claimed that portions of each case were his sole and separate property and argued that all of one of the cases was his separate property as having been started after the service of the petition. Husband further presented that he had retired from the practice of law and now was on Social Security earnings. It's important to note that husband...
Counsel, what is the date that the trial court should decide when the community has ended?
Well, it has the discretion to decide that date. This is an asset. We're valuing an asset. And in that case, I think it takes us out of the typical earnings case.
But counsel, don't we have to decide that first before we decide the value of the asset? Because the value of the asset, I mean, how it's apportioned is determined by when the community ended, correct?
Well, not necessarily. And it's interesting because it was pointed out right off the bat that now we're under a different statute than Garrett.
Well, so what, if it's not the date of serving the petition, then what is that date?
Well, the court has the discretion to decide that. There's all kinds of cases saying the court has the discretion to decide the appropriate valuation date.
Is that really true? I mean, the statute, I think, is pretty clear. The statutes are pretty clear on this.
It says the community terminates on that date.
Yes, but then you apply the Garrett factors and determine the percentage before and after that date as to the effort that's involved.
Well, that may be true if there's no concern about the veracity about the information that's been presented on when certain work was done. Wife came in and said husband purposefully tried to monkey with his hours to reduce the community interest in it. So
that may or may not be true, and those are factual matters for the trial court to figure out.
That's true in the trial court.
But it has to have a date by which it can judge all that by.
Okay, and it came up with that date, the date of dissolution. Because it was interesting that the trial court said that his presentation relating to the practice issues was, quote, suspect. The trial court had issues with his testimony on phasing out his business and being retired. So in that case, again, we've got a valuation issue. The court's stuck in that conundrum of going, I don't necessarily believe what I've been given regarding when this work may have been done on these cases. So what the court did was just saying, fine, I'm going to cut it off at the date of the decree. Anything that he does post-decree, fine, that's going to be a separate property. And actually that goes back to the law where when we're talking about a property issue and there's a dispute on whether it's community or sole and separate, with husband taking the position that it's sole and separate, he has to prove that by clear and convincing evidence. And that means he had to do more. He had to even show what the contracts were to determine, what portion of it was community and what part of it was separate. And he did not do that.
Aren't those issues that get to be resolved when and if those contingent fees are realized?
Well, I would agree with you that the law allows the court to retain jurisdiction to make the final apportionment when the case is done and all the fees are in, and then it's able to look at, what those post-decree fees are versus the pre-decree. But I don't believe that it was an abuse of the discretion in this case for the court to find that he did not meet his burden to prove his sole and separate interest, and therefore to have that date of valuation be the date of the decree.
Well, I'm not so sure we're in an abuse of discretion area here if we're talking about interpreting and applying a statute or two statutes that determine when the community terminates.
Well, but isn't the establishment of a valuation date an abuse of discretion standard?
I'm not sure we're communicating on this. I could be wrong, but I believe the statutes talk about the termination of the community date, and it's set forth in the statute.
Okay, but I would agree with you if we were dealing with normal earnings where he's got a paycheck that he's getting from Motorola that says he got paid X number of dollars during this period of time, and we can identify when it was post-service. In this case,
I don't think it's a big mystery after Garrett as to the construct that you apply once you have the data, and then the trial court takes evidence on those issues, including these credibility issues that you want to argue here today.
Exactly, but that's just it. The only evidence that he presented were the timesheets for two of the cases where he says what his hours were on certain dates. If the court finds that suspect and says, I don't believe that, and therefore doesn't consider that proof of his income during that time between service and the petition and the entry of the decree, then he hasn't met his burden, and the court is justified in dividing the fees up to the date of the decree.
Counsel, it seems like we're ships passing here. I'm assuming just for purposes of discussing this with you, let's assume that you are correct, that Mr. BACHRACH is doing a bunch of the improper things to minimize his income. That's a factual matter for the trial court to figure out. The date by which you judge that, though, it seems to be a matter of statute, and that's the date that the petition is filed, and that is how the trial court faces the issue. Giving a date,
Okay.
How was that income earned, and applying the Garrett factors, but you have to know the date, and that's determined by law.
Okay, but is it that cut and dried? Because the statute changed after Garrett. Okay, when we look at ARS 25-211, they added subsection B long after that. It says, notwithstanding subsection A, even when there's service of petition for dissolution, it does not alter the duties and rights of either spouse with respect to the management of community property. So you've still got that issue of there's a case there, there's an obligation for the husband to maintain that asset to be able to pay wife for her interest in it. So is it really that straightforward that if husband then comes in and says, I didn't do much of any work at all before the service, and doesn't have any itemization of fees, and then says, after the date of service, Now all of a sudden I've got all of these fees and phone calls and research and such. Do we automatically have to believe that in doing the apportionment? Isn't that the court's job to make that determination whether that evidence is believable? And didn't the court make it clear what her thoughts were on this by saying that it was suspect? Well, I'm going to move on to the apportionment of the artwork, unless you had other questions. Now, the apportionment of the artwork has to be considered in connection with the overall division of all of the marital assets. Husband received woodworking tools that had significant value. Wife had estimated in her evidence that it had a value of at least $40,000 to $50,000, and she presented an exhibit, number 6, that supported that valuation with current values of the items that husband had. The trial court noted husband received virtually all of the contents of the house, other than wife's personal property and clothes, some things that she had taken out early on. And I want to make this note, even though it goes against what the trial court said, I think it's relevant to whether what the court ultimately did was allowable. And that is, the value of husband's tools should not have been offset with the value of wife's jewelry, as the evidence from the trial court, if you take a close look at it, clearly established that the jewelry was wife's sole and separate property. When they were questioned, both parties testified the jewelry is intended to be gifts to wife. There was no statement that it was an investment or that it was otherwise intended to be a community property. Husband's testimony was clear. Yes, it was a gift to wife, and that's it. The trial court had said it was a disputed issue, and then therefore did the offset. But there's no evidence that that it was a disputed issue. It's interesting that in the order, the trial court just found that the artwork did not have a market value. So it's just saying none of them sold, so I can't say what the value is. This finding was appropriate, as the parties agreed. None of the paintings had ever sold. So husband ended up with his tools and the contents of the house, and wife ended up with her jewelry that should have been her sole and separate property, and the paintings. Thus, the court's decision, it's supported by an implicit balancing of the assets that were apportioned, and the court ends its order by saying, in fairness and equity, all of mother's paintings shall be returned to her as her personal property. So the court's saying they just felt it was fair to have this kind of apportionment. As a note, I think husband was a little disingenuous in saying he offered to buy the paintings for $1,500 apiece. If you look closely at the testimony, there's never a point where the husband says that he has the money and he'll hand her the money to pay her for it. What his testimony is this offer is contingent on getting the money someday to pay for it. And he goes on and says, I would pay $1,500 any day for that artwork if I had that. So the question was presented, did husband truly make the offer to buy it? And I would suggest that the testimony shows that he did not. Before I forget, I do want to go back and make one more point on the division of the attorney's fees issue. And just by the questioning of the court and having a concern of a remand, I do want to make a request that if the court remands this, that it's made clear to the trial court that they are able to cure deficiencies in their order without doing another trial or without doing more. Just from my experience in doing remand proceedings, oftentimes the courts are not familiar with what their responsibilities are, and so to the extent that you believe that if there's an issue and it can be cured by the court just making additional findings based upon the evidence that was presented, that's clear to the court. Now, the last issue that we have is the spousal maintenance. Now, the trial court addressed the statutory factors under 25-319 that it's supposed to. The trial court determined the wife qualified for an award of spousal maintenance under 319A, and then going to 319B, we need to look at the statute, especially for this particular issue. It says, the maintenance order shall be in an amount and for a period of time as the court deems just, without regard to marital misconduct and after considering the relevant factors. It's as the court deems just, not as the person requesting spousal maintenance states their claim and then is limited to what they ask for. Now, after going through the analysis of each one of the factors under 319B, the court did reach an independent determination on the appropriate amount and duration of the spousal maintenance, not accepting the amount or the duration submitted by wife, as is authorized by the statute. And I just would point out that there is no statutory limitation of an award of spousal maintenance on the duration requested by a party.
Well, what would be, based on the evidence that was presented to the trial court, what would be the evidentiary support for extending this support period to 10 years?
Well, I mean, you can look at the pretrial, and I do want to point out that the parties did actually provide testimony or they stipulated that each of the parties would testify consistent with the pretrial, so the pretrial positions can be considered evidence in this particular case. Wife laid out her statutory basis for the spousal maintenance, and just when you start out with the idea that it's a 15-year marriage, she never worked during the marriage, she actually was brought from Russia to the United States at the beginning of the marriage.
No, it's really simple. What can we tie that 10 years to? Is there some event 10 years down the road that makes sense for doing this?
Well, how do we ever tie it to an event as far as spousal maintenance is concerned?
Well, I don't know.
The court
she said she wanted to complete her education. Was that going to take 10 years?
Potentially. But the court doesn't necessarily have to take the person's optimistic view of what they're going to accomplish within a period of time. And the judges certainly have experience of people saying, I'm going to go back to school. It's going to take me 3 years to get this certification or this degree. And between having kids and between getting divorced and things like that, they typically find out that they may have been a little optimistic in the time frame that they could get things done. And the court has that ability to say, well, given the uphill battle that she's got and where she's starting out from, I think it's going to take her 10 years to get to that point, not 5.
Even though she and presumably her lawyer, asked for 5, based on the case that they knew and the evidence that was in the record.
Well, sure, but yeah, but why are we focusing on that? I mean, just as a hypothetical, if somebody comes in that has been married for 35 years, never held a job, and is now disabled, and because they come into court and say, well, I only need spousal maintenance for 6 months at $500 a month, while husband makes $100,000 a year, the court's limited to giving them what they asked for when the court has the independent view of going, that ain't going to do it.
Well, I guess I'm skeptical that scenario would ever present itself.
Well, and that's an exaggeration, but where's the cutoff? I mean, there's no due process argument here. Wife disclosed everything. It's clear in the pretrial. She goes through the statutory factors and gives her position on each one of those to support how long the award should be. The court is free to look at those factors and reach at a different amount than presented by the party.
Did the court consider a husband's ability to pay?
Well, it's presumed that it did. there's not a requirement that the court make the findings, and if there is evidence on the record that would support the husband's ability to pay, then it's okay, because, and there is evidence there, because not only is husband an attorney that's practiced for a lot of years, that he's got conditions, but he's had them for more than 10 years, and he's been taking medications that have been controlling them, and besides his ability to work, he's got a $400,000 personal injury receipt from the wrongful death of his son, so he's got assets to pay the spousal maintenance. So the evidence from the trial supports a finding in that area, even though I understand what you're saying is in her particular order under the statutory factor of whether husband can pay it and still support himself, she cites two different factors. So I get that. I saw that, but again, she's not required to lay out that factor if there's evidence on the record to support it.
Thank you, counsel. Your time is concluded. Counsel, does the talker have discretion to determine when the marital community is terminated?
No. It's statutory. The valuation cases are that where they can pick the valuation date. Cases like Sample and these types of cases are hard assets, houses and those types of things that aren't this. They aren't the result of labor. That's where the Garrett case distinguishes those cases. So Sample is to pick a house valuation date. Okay, if it's 2 years later and the market went up through nothing to do with one of the parties' effort, okay, you can use a different valuation date. That doesn't deal with actual effort, which is what the Garrett case discusses. The spousal maintenance point, if we look at the Smith v. Tang case, it goes to exactly what Judge Winthrop stated, which was the plaintiff in the case is in the best position to assert what their damages are and request the amount that they deem fit, is essentially what Smith v. Tang stated, and the court should not go around that because they're in the position to make the request. Here, the trial court made findings about how long it would take wife to get an education, 2 years, which is what they stated that the bachelor's degree would take if she transferred her credits based on her testimony. They went outside of her requests, and again, husband had no ability to question on it because what's the point of having a pretrial if the court can pick something outside the parties' positions? The other thing that we point out is that if we look at the Leathers case, and there's a comment when this court sent Leathers back about the end result of the spousal maintenance putting more resources in the party who was receiving it than the other side. I know I'm out of time. And made a comment about that.
Thank you, counsel. We appreciate your arguments today. We'll take this matter under advisement and issue a decision in due course. We're going to sit at recess here on the bench while the next case comes up. Thank you.